Court of Appeals Division 1 is now in session.
Thank you, folks. Go ahead and have a seat. Good morning. Those of you who are comfortable, and I think most folks already have, please feel free to remove your masks for the argument. We are here for oral argument in 1 CACV 20-0396 Lane v. Statesman. As you know, we do record and live stream these proceedings, so please give your name and the name of your client when you begin. According to current protocol, you will argue from council table. You are welcome to remain seated, but we have now gotten these lovely podiums for you to use with microphones. So you're welcome to stand. You do have a maximum of 20 minutes per side. Although you are not obligated to use the entire time, we do keep track of your time, and we require you to keep track of your own time as well. The clock on the podium should be visible for you if you're standing. If for some reason you can't see it, you are welcome to move around to see what time you have remaining. And the time on the podium does reflect the remaining minutes that you have, including any time you wish to reserve for rebuttal. We recognize you cannot easily see it again, so please feel free to move around. I will try and give you some signposts just in case. Please keep in mind that we have read the briefs, we have studied the record, and we have discussed this case in conference. Please, with that in mind, you may proceed, counsel.
Thank you, Your Honor. Good morning, Your Honors. My name is Jared Simmons with Simmons & Gottfried. I represent Statesman Sales and Marketing, and I would like to reserve 4 minutes for rebuttal, please. Your Honors, I will focus my presentation on the issues of treble damages and, of course, address any questions that you may have. Statesman requests that you reverse the lower court's ruling trebling the damages because they were awarded in an error of law and fact. I will be addressing 3 main points. First, it is objectively reasonable, good faith, for a company to rely upon and seek to enforce its contracts with its employees. Number 2, Statesman was entitled to seek offsets set forth in its agreements and for amounts conceded to being offset by plaintiff. And 3, the lower court erred as a matter of law when it did not determine and give effect to the contract pursuant to the party's intention after determined ambiguities existed.
So with that, counsel, are you contesting or challenging the court's summary judgment ruling?
Yes.
As to 10.2, as section 10.2?
Yes, Your Honor, because it is our contention that when the motion for summary judgment was granted, excising that provision of the contract, instead of trying to resolve an ambiguity, the court simply removed it, creating significant holes in the party's contract, rendering meaningless or changing the meaning of other provisions in the contract.
Well, let's focus on that for a minute.
Sure.
How do you read the court's ruling? Did the court err in treating it as a liquidated damages clause?
It did.
And how so?
Because, Your Honor, even though the words liquidated damages are in the provision, when you looked at the entire context of the contract, it was very similar to the contract in the thermokinetic case. And I know the court tried to distinguish that case, but it's the effect and the intent of the parties. And the court was required, pursuant to lots of case law that the courts recognize, to resolve any ambiguities in favor of the intention of the parties. And what it did is, by excising X2 and saying that, look, no commissions are going to be forfeited, it rendered meaningless, for example, section 10.4, which said we were going to use part of the standard fee commission that remains to pay others to complete the work from the leaving prior salesperson.
Okay, so assume that the court was wrong.
Yes.
Assume for argument the court was wrong in treating it as a liquidated damages clause. Where does that take us next?
Because, Your Honor, it should have been treated as a forfeiture provision under the guise of the same analysis, again, in thermokinetic, which is it's permissible if the parties agree up front in their contract that we are going to have this understanding. And that's really forms the basis of our entire argument, which is at the time these parties entered into the contract, they could not foresee that 3 years after litigation was commenced, or pardon me, 3 years after Ms. Lane was terminated, that provisions of their contract would be materially changed or excised. So the court was required to look at what Statesman's thinking was and the intent of the parties at the time the contract was entered into, which was You leave, we take some of your commissions, we pay those to other people to complete the work that everyone agrees. There's very few undisputed facts in this case, but two of them exist, which is other people had to do the work necessary to close these transactions.
Counsel,
Yes.
turning to 10-2, I understand it's not liquidated damages, but what is that, I guess you would say forfeited, is any and all monies. There's no distinction between earned or unearned. It says any, so let's say Statesman, your client, didn't have the money to cover a commission on the front end, the first half, and there was some sort of understanding, we'll get there, and she's terminated in the interim. The way this reads is whether it's earned or unearned, it's gone.
And Your Honor, the very simple explanation. Because they are commission salespeople, they only got money that they earned. There was no other money due to them. So unless they earned a commission, they didn't have any wages remaining.
I think your point is, from the case we keep talking about, there's a difference between earned and unearned.
That's correct.
But this says all.
Right. And in that context, in dealing with this specific situation, there was no other compensation except that which was earned. So it didn't matter. So that's what I'm saying is that because they were commissions, you had to achieve a commissionable payment by getting a contract in place. That was when you earned the first half, and when the transaction closed, you earned the second half.
Let me ask this, counsel. Would you concede that to the extent X2 tries to give the power to claw back earnings, which arguably it does, that would not be something that would be allowed under Arizona law, specifically in terms of earned wages?
Yes, Your Honor. And again, I totally agree. That provision is very inartfully worded. There's no doubt about that. We concede that right up front. And that's why it was really incumbent upon the court to say, look, we recognize that there's ambiguities here. Let's resolve this in a way that makes it true to the intent of the parties, because it was not the intent of the parties to claw back monies that the employee had earned.
Why do we have 10.2 or X2 and 9.3 if they essentially were designed to do the exact same thing?
Because, Your Honor, they really kind of warn, and again, this again goes to the inartful drafting of the contract, which is that ultimately the parties intended that there would be some of the standard fee commission remaining if that salesperson left to pay the people who were going to complete the work. And again, that's one of the provisions that everyone agrees to, which is that other people had to complete this work. And Ms. Blackwell is a great example. She was called in specifically to try to usher these people through closing, because sometimes these things didn't close for months or years after the purchase agreement went into place.
But I still don't understand why we have two. It seems to me they both do the exact same thing, different words.
Yes.
So why are there two? And if you can't explain it, that's fine. It's your client.
Yeah, I didn't draft the contract, Your Honor, but my understanding is that, to your point, that they basically do the same thing, but that one was, for lack of a better word, very inartfully drafted, and it was confusing. And I think the court got confused because the language liquidated damages led the court to believe it was actually a liquidated damages provision. And the case law and the law in Arizona, it's clearly not, because there was not a breach that activated Section 10.2. And so it wouldn't accordingly be a true liquidated damages provision.
Well, neither of them really called for a breach. It just called for the person to not be employed.
Correct. And under those circumstances, that's why this case is extraordinarily similar to the Thermokinetic case. Thermokinetic is a contract that deals in the exact same industry. And it's industry standard, as my client had testified to at trial, that when a salesperson leaves, they get no further commission because they all understand we have to pay other people to complete the work.
So, counsel, let me ask you something. Sure. Listening to you, it sounds like you would agree that 10.2 in and of itself is void as against Arizona's statute and the wage statute.
No, I don't think it is. I apologize. I don't think that it's voidable. I think that what happened is it needed to be modified because it was ambiguous. It was listed as a liquidated damage provision when it wasn't. So it was an ambiguous provision.
Right. Let's say it's not a liquidate. We'll put that in the next room.
Yeah.
And we'll look at these terms and whether or not they comply with the wage statute or not, as written, not as penciled.
Mm-hmm.
Is it void?
No. Because again, it's not void for the same reasons that a similar provision in thermokinetics agreement was not void. It wasn't truly the parties had agreed up front and in writing that if you leave, we're going to use the remainder of your commission to pay people who come after you.
Right, well, there's a separate clause you have that's, in your words, more artfully drawn, right, in this contract.
Yes.
And
If
so
you're saying, are they
I'm not saying what that
redundant?
would mean if
Yeah.
it's void, but I'm just asking you whether this provision survives Arizona law.
Your Honor, again, I think it does. Do I think it's redundant basically with Section 9.3? Yes, I would concede I think it's redundant with Section 9.3. But having redundancies in contracts doesn't necessarily make Section 10.2 void. What it does is, if it's looked at in the context in which the parties intended, it would have been seen as it's really an acceptable forfeiture provision, just like the one in thermokinetic,
Well,
which
you
is
have
the
a
same.
provision usually in contracts that says if anything is struck, the agreement will go forward
Correct.
without that.
Yes.
I understand that.
Yeah.
And that's not my question. Although, did this contract have such a term?
Yes, it had an integration clause.
Okay. This clause, again, in and of itself, not as interpreted in connection with other statutes, does it survive Arizona law?
Again, Your Honor, the way that it's worded is it's frankly confusing to me too, because it does say liquidated damages, but I believe that it does. And to
What
respond.
about the phrase any and all, though? Any
Oh, the any and all
Any and
part?
all, yeah,
I think in this context, it does as well, because any and all commission, there could only be earned commissions. You can't have unearned commissions. So that's what the issue is that when they earned their commission, and again, to the court's point, the intent of the parties was not to deprive the salesperson, and that was never even an argument that was ever made, which is it was intended to deprive her entire commission, and that was never even brought up. I know it was mentioned, but the truth is that that's not the effect of it, and that's not what the parties intended. And had the court talked to the parties and tried to discern what the intent of that provision was, it would have been, to the court's point, not to deprive the salesperson of any commissions and all commissions. But in this context, the only commissions it could be would be earned commissions. But if it hadn't been paid out at the time that the employee was terminated, but the employee had earned it, Statesman would have paid it. And I believe that they had an obligation to pay it. And I think the court would have been correct to correct the ambiguous language in the contract to say that, to make sure it was clear.
Let me try and go at this with a surgical knife.
Sure.
There's a first half commission and a second half commission. She had earned the first half commission.
Yes.
To the extent Section X2, 10.2, I don't quite know which
Yeah.
it should be called, but to the extent that section tried to take back the first half commission on its terms, I thought I heard you say you would agree that would be in violation of Arizona law. You didn't take that position, but that if it was read that way, that would not stand.
I agree.
But it could stand to the extent it was the second half commission.
I agree.
So I
And
think
yes.
you're saying half of it would be violated, if it was read as broadly as it could be read,
Yes.
it would violate Arizona law.
Yes.
But you're suggesting we should read it more narrowly, that complies with Arizona law and allows it to stand.
And I think the trial court was required to do exactly that, because ambiguities, and there's, again, tons of case law on this, when the parties have an ambiguity in the contract, number one is, and it can be read different ways, that's not grounds for treble damages in any event. That's not penalized, and that was the holding in Cummings, and frankly, the holding in thermokinetic, which is you have an agreement, if you deprive people of commissions, it's not necessarily bad faith. And in this case, because the contract existed with the language that it did at the time, they never sought to enforce to claw back any monies.
So
But-
if we just disregard X2, don't we get to the same result under 9.3?
Yes, and that was
So
our.
it really doesn't matter.
I don't think it does matter that much, and that was kind of our argument to the trial court, which is you struck one provision of the contract that we agree is inartfully drafted, and we get it. But there's a whole nother provision over here that has never been asked to be stricken, that no one has ever voiced any kind of a problem with, and we're relying on that provision which is what the parties' agreement was at the time they entered into it, and here's what everybody understood moving forward. It wasn't until after litigation was filed and after the motion for summary judgment was granted that bad faith was retroactively attributed back to Statesman, saying you don't have the right to rely upon your contracts anymore. Even though I've never stricken 9.3, you don't have the right to continue to go forward with the claim that you get to enforce your contracts. And I think it was reasonable for them to do that, a reasonable good faith dispute.
Then let's assume we agree with you for 9.3, just for sake of argument. What happens with the $1,330, that odd amount? I don't know exactly what it is. It seems to me that that amount is owed no matter what, based on what happened at the trial court level, that there was a motion for new trial court denied it, and that amount stands regardless. And how do we get around that, if you think we get around that?
Your Honor, I think it's very simple. We are not really arguing that our position is truthfully that she didn't earn it. But even assuming if we were wrong, what we're really contesting is the award of punitive damages against my client in the form of treble damages, which clearly were not warranted under these circumstances. It is objectively reasonable for my client to have relied upon the agreement of the parties at the time that they decided, we don't owe you any further wages. That was the plaintiff's agreement. That was the company's agreement. It wasn't until many years later, after a court got involved, that the court decided, I've stricken this provision, you still are not paying, I'm going to attribute bad faith from that point. And we believe that the decision d'amico that this court made, saying that really you're supposed to look at the facts contemporaneously with what the party's knowledge was at the time, should control. And I think that's where we have a problem, is that you can't attribute retroactive bad faith, because really the entire line of cases that have dealt with this problem, every single solitary one, has said the employer knew at the time wages were actually due to the plaintiff, or actually due to the employee, and for some unknown reason decided not to pay. Here we had a contract that says we don't owe you any further money.
Let me make sure one thing's clear. Then under X2, you're not taking the position she's not owed the $1,330. You're taking the position she's not owed the $1,330 solely because it was a split commission with another salesperson as raised in the new trial.
That's correct.
Okay.
We're saying in addition to our belief that she was not owed those funds because she agreed to it, and our contract said she didn't owe it, we also had reasonable offsets. And that goes to the court's question, which is we had a reasonable offset. One was we used some of those commissions to pay somebody else. And the other part of it is they acknowledged and admitted at the trial that we had a reasonable offset for about $3,700 because she failed to return the draw. If you take those two together, that's almost the entire amount she's claiming. And so that was our big problem, is that we had legitimate good faith disputes as to that she's entitled to any wages. And number two is that we had reasonable good faith belief that we're entitled to offsets, one of which they consented to. And awarding treble damages under those circumstances is incorrect as a matter of law. The case law, not a single case in Arizona, and plaintiff has not been able to point this court to a single piece of precedent, has shown that when an employer relied upon the plain language of its contract that wages were not to be paid after termination, that subjected them to punitive damages. And I think that's where the error lies. More so than that it was a question of, it was a reasonable good faith dispute whether or not she was owed those wages. If we were wrong and the courts determined, yes, she's entitled to those wages, okay, that's fine. But that does not take away from the fact that we had a reasonable good faith dispute. And under every case that's ever interpreted the punitive damages statute, that is enough. We don't have to be right. We just have to be reasonable in our good faith dispute. And that's what we were. Relying upon plainly worded contracts is not an issue. Your Honor, I have 2 minutes left. I'm going to try to reserve my time, but if you have any further questions, I'm happy to answer them.
I think we're good. Thank you.
Thank you.
Counsel?
Thank you, Your Honor. If it may please the court, I'm Joshua Carden representing the appellee Melanie Lane. Arizona employees are entitled to receive what they've earned. And Judge Goss, I'm going to disagree with you slightly. I don't believe this was a two-part commission in the sense that the contract itself emphasizes with all caps that there is one commission only to be paid. Now, is it paid in two different buckets? Absolutely it is. We don't dispute that. Once is when the earnest money is received, and then again at the end when the sale is completed. It was astounding to learn during the course of this trial that after 25 years of doing business in Arizona, apparently Statesman has never paid the same agent for both halves of the one commission. That somehow they have either brought new agents in, they have brought at the end a third-party closing company in. They couldn't identify a single time where the agent had actually received both halves of the earned commission, even on sales that later closed. And Judge Weinswag, I think your question really goes to the heart of the matter, and the reason why Judge Kiley recognized this was an unlawful forfeiture clause was to say any and all. I mean, that's very broad language. It doesn't say you'll forfeit the second half of the one commission. It says you'll forfeit any and all monies of the standard commission, which means that Statesman could have just as easily said, we fired you, we want it all back. And if
But counsel, we don't even get to whether it's unlawful forfeiture unless it's a liquidated damages clause. Well, let's start there. Is it?
I think it has to be.
Why?
Well, it's got the language in there.
But that's a label.
It is a label, but it only kicks in if the employee is gone for any reason.
But there's no breach language, nor is there any. What would be the difficulty in ascertaining damages? That's the essence of a liquidated damages clause, isn't it?
The essence of a liquidated damages clause, yes. I mean, the amount is set forth as the entire commission. I mean, the amount is set forth in the clause.
But that's easily calculable. You take the sales price, 1.5%.
Sure.
I guess I'm not. But let's assume that it's not, just for sake of argument. Let's assume it's not a liquidated damages clause. How does your take us? What's the next step?
The next step is, did my client actually, we just go back to, did she earn it or not? I mean, to me, that is the next step, is to say.
And what language supports that she earned it? I mean, that she earned the 1.5 as soon as the pen was set down, the ink was dry on the sales contract.
Exhibit A to the agreement, which was what we were looking at earlier, is Trial Exhibit 3. It just says the commission is earned, paid per unit upon executed purchase contract, and the second half when sold. And I'm sorry, I've got to get my readers on here. I didn't used to have to have.
That's okay. And if the word earned is in there, I mean, please tell us where it is.
Oh, it's not, Your Honor.
Not?
That's a fair question, Judge Brown. I'm sorry. It just says when it's paid, and so presumably, I mean, at some level, the court can look at that and say, well, all they could earn here was commissions. So if this is the deciding line to say, when does your right to receive a commission arise? According to the language in Exhibit A or Schedule A, it's once the purchase contract is sold, you get half now and half later when it closes. So if we're really going down that road, the fear for me is to say we're going to see a proliferation of employment contracts for regular wages that say, hey, you want to get paid, you better survive till payday. Not, if you work the 13 days before your 2-week pay period, but you're gone on the 14th day, we don't owe you anything, regardless of the reason why you might no longer be here. That's a concern if the court were to adopt Statesman's interpretation of when someone's entitled to wages or not.
Would you agree that if they had used the word earned, if they had said the first half commission is earned when this happens, the second half commission is earned when that happens, that would be okay, would comply with Arizona law?
I actually think it would be, and to me, that's what the court below found was the clear distinguishing mark between Oliver. Well, let me modify that answer just a little bit, Judge. It would be closer to Oliver. The only other difference there is the Oliver contract stated very clearly, the thermokinetic Oliver contract stated very clearly what the second half of the commission was going to be used for. But it did also have the split language. You earn half of your commission now, you earn half of your commission later. And I think that would have been a different case than what we are dealing with here.
I'm going to try and tease out a distinction. You said all employees survive till payday or you're not going to get paid.
Right.
But there's a difference between a commission salesperson, a piece worker,
Sure.
and someone who is paid hourly or salary.
Agreed.
And isn't that really the distinction that we're dealing with here? Your analysis and your analogy fails, or actually is very strong with regard to hourly employees,
It would be.
salaried employees.
And
But
that's-
commission folks, the deal has to close before you earn anything. That's just a tradition under commission.
Yes, and I agree with that. And so then the danger becomes, let's just take the general sales employee, forget real estate for just a second. And these cases do exist where you're on a draw, roughly minimum wage. You just sold that $1 million deal. You're excited. Company's been paid. You're fired before payday. Do you have an expectation of receiving that commission that has closed, it's funded, every other criteria that's ever been identified in the company books has been fulfilled, and yet they say, oh, sorry, must be present to win. I think the employees win those cases precisely because when the court looks at them, they say, did they earn it or not? Was there anything left to do except cash the check? And the answer is no.
Isn't it the same thing when they say, look, you're right, you signed the deal, the ink is dry, and we're paying you half, and you get the other half when we get the final check?
Correct.
Why can't they do that?
They can do that, they just can't not pay the person who sold the deal. They can say, we're waiting until the deal closes, that's totally fine. But when the paperwork, the contract between the parties that Statesman emphasizes so strongly says there's just one commission. There's no provision that says, other than 10.2 that says you forfeit all of it if you're not here anymore. Besides that, there's only one commission, and that's why I made my rather law nerdy commission subsequent argument, and to say I don't see these very often, but in this particular case, when the only distinction is did the sale fund or not, is there anything left, and the judge very adroitly analyzed the evidence below, which was Ms. Blackwell, the other sales agent who testified, and Ms. Lane both said, hey, our job was to sell, sell, sell. They had other people handling the closing duties. Did that change eventually? Yes, it only changed after Ms. Lane had been fired. Ms. Blackwell said suddenly, and there's evidence in the record, why am I being asked to do all these things that none of the salespeople have been ever asked to do before? Can Statesman assign other duties? Oh, of course they can. What they can't do is take away earned commissions just because they feel like it. And apparently,
Let
yes.
me jump in here.
Sure.
I understand. It says in bold, one commission only. You're absolutely correct. Then in the next section, or subsection B, says the standard fee commission outlined above will be distributed as follows. 1.5% commission paid, all caps, equally to all sales professionals. I'm scratching my head to know what that means, when it's applied, how it's applied. Everybody gets a 1.5? That's in the office?
No, I don't think that's how it worked in practicality. It didn't really come up as a major argument at trial. Where it did come up was in the trial commission spreadsheet. You will see several examples. That was trial exhibit 12. You'll see several examples where there are multiple salespeople who worked on the sale up front with the client, and there are multiple names. And so, yes, there were occasions where split commissions would happen for the one commission for the people who worked to make the sale happen.
In those cases, it's splitting the 1.5. It's not additional 1.5.
That's correct. And again, we could argue about, what that language actually means and such, but practically speaking, the evidence showed that if multiple people worked on the sale portion of the deal, those people got some portion of the first half of the commission. And that was the issue related to Ms. Atunez. Ms. Mann, Statesman's owner, testified at trial that, there seems to be a clerical error where we didn't pay Ms. Lane what she was owed for that particular deal. And that's why Judge Kiley didn't treble that. He said, hey, that's a good example of where there is a good faith dispute. There was a math error there. He didn't treble that portion. Had he, I think that would have been legal error because it wasn't even elicited until Ms. Mann testified to that at trial. Going back though, Statesman has said basically that, well, we don't know why it's wrong to deprive everyone of the second half of their commission because we've always done it that way. That's not a great argument to support depriving people of underpaying wages. The equivalent again would be under, federal law, well, we don't pay overtime. We just never have. We've been in business 25 years. No one's ever sued us. We don't pay overtime. Statesman wrote these documents, may not have been my colleague who wrote them personally, but these are Statesman's contracts. It was Statesman's decision to include an incredibly broad forfeiture clause. It was Statesman's decision to refuse to pay its people, instead firing them before they had to pay the second half. And Judge Kiley finally got around to that. I made that argument pretty early in the case. And finally, in one of his last rulings, he said, if Statesman is really saying that in all this time they've never paid an agent a second half of this earned commission, maybe this was a scheme. Maybe this was the plan all along, and this is just the way they do it, where they revolve people out the door after the first half is paid, and they don't pay another agent that commission.
Even if that was the case, I think you've acknowledged is if they had changed some of the words in the contract, it would be perfectly legal. It's not an unlawful scheme. And I don't think we punish people under those circumstances with the treble damages, if it was lawful to do it.
And my understanding, Judge, is that the trial court rested that really on two particular findings. One was the forfeiture provisions and the actual interpretation of the forfeiture provisions. And the second was Statesman's selective enforcement of its contract when it saw fit.
Let me ask you this.
Yes.
Because this is one of the points I asked your opposing counsel about. Let's just forget about X2 or 10.2.
Okay.
Was Judge Kiley right about 9.3? It doesn't seem to me that it is the same. And if 9.3 stands, aren't we just in the same place? And the only issue is that $1,330.
I think that's correct because to me 9.3 is worded differently than 10.2 is. 9.3 I would say is a more standard clause that I've seen in employment agreements. Okay, 10.2 was one of those "are you kidding me" clauses. 9.3 is, hey, if you don't work here anymore, we don't owe you anything after you're not working here beyond what you've earned.
And so the crux of your argument really is that there is one commission paid in two parts.
As Statesman has outlined it, that's the crux of it. So if Ms. Lane doesn't work here any longer after a certain date, Statesman's job is to say, what did she earn? How much was it? And pay that to her. And instead, originally they just stood behind 10.2s to say, oh, we don't have to pay the other half of the one commission. They weren't here anymore. And again, that's the thing that takes this outside of, we don't just have 9.3. We don't just have a semi-standard clause that says, hey, you don't owe us anything, we don't owe you anything, this relationship's done, you do still owe us your duty of confidentiality, and they incorporate some of those provisions. It's like a case with a restrictive covenant. Hey, you're out, we don't owe you anything, you don't owe us anything, except you do still need to comply with these obligations.
Counsel, let me jump in there.
Sure.
Back to, I know both briefs had cited cases about, what does it mean earned? It's you do the work, or somebody cited to something about shaking the fruit from the tree, right? And that's the person that does the work should be paid, the policy behind this. So where does that get us? Let me give you just a hypo, and the hypo may fail, but I understand. I'll give it a shot.
Okay?
So the agent, the sales agent has customers in, ready to do the deal. They sign all the paperwork. The conditions that are required under the contract are fulfilled. The ink dries, entitled to first half commission, right?
Right.
Agent walks the keys across the hall, says, I'm sick of this job. I'm out of here. See you later. By the way, I look forward to getting my second half commission. How is it fair when you talk about shaking the trees? Who's going to come and pick up the fruit of from that point to get it 6 months, a year down the road to get that thing to close? We all know, I mean, if you bought homes or bought townhouses or condos, it's sort of a pain to walk the walk through that process and get your financing, go to the design center, do all that. Who's helping?
The testimony below was that Ms. Mann's sister was a closing coordinator and that it was other people who were responsible for doing the dull back-end work, that the salespeople were told, sell, sell, sell. Get back out there. It is not your job. Once you got the ink on the thing, yeah, you're sitting there and people come in and talk to you, but once the ink's dried on the contract.
It's not for the sales agent.
Not for the sales agent anymore. Now, Statesman has argued vehemently that's not the case. Judge Kiley resolved that factual dispute at trial and said, nowhere in your pre-litigation communications did you ever say that. Not your letter from the COO, and especially not Exhibit 23, where as soon as the sale happened, Ms. Mann emails and says, here's your commission worksheet. You're going to get a third of the commission for this one. And then as regard to Unit 437, you're going to get the sales incentive of $2,450. That's the only one that Judge Kiley awarded Ms. Lane, incidentally. And then she gives the grand total, $12,666 for just 1 week's work. That was the entire commission, both halves, plus the sales incentive. It wasn't, and be sure you keep up with Unit 437, because if you don't, you might not get the second half of the commission. So the owner.
What does that mean? If it's not that there's more work to be done?
Keep up the great work?
No, keep up with the 437 or you might not get the second half.
Oh, forgive me. That's what is not in that email.
Okay.
She doesn't say that at
I'm
all.
sorry, I was just going to say, I thought
Forgive
you
me,
said
yes.
that was there, I thought.
Like, no. She says, here's $12,666, and you look at the spreadsheet for that unit. That's the first half, that's the second half, and the sales incentive all rolled into one number. That's the president of the company saying, here's what you get. Right after the sale. Nothing else has taken place. Nobody ever said in these pre-suit correspondences, don't forget, you still got to print, in triplicate the contract and prepare all the closing documents. They had somebody to do that, and that's why Judge Kiley said, unlawful forfeiture, here's what was earned. It's both halves of the commission. He made the one award of the sales incentive. That was my one disappointment from his ruling below, was he didn't, award all the sales incentives, although the language suggested that might have been the case. But, we chose not to appeal that issue, and we're here asking the court to affirm. He got it right on the amounts. He got it right denying the set-offs. He got it right that there was substantial evidence that reasonable people could decide, this wasn't a good faith dispute. Statesman was doing everything it could to avoid paying its second half of the one earned commission. By the language of the contracts, Ms. Lane was entitled to the amounts due. And so we would ask the court to affirm and also to award attorney's fees in this wage dispute. And with that, I'll sit down unless there are any further questions. Thank you.
Your Honor, first I want to correct. Opposing counsel has repeatedly said that Statesman did not pay anything to salespeople for the second half of the commission, and that's just frankly not true. At trial, Mr. Carden asked Polly Blackwell, the only other salesperson other than Ms. Lane who was there, he asked, all right, while you were employed, did you get the second half of your commissions for those sales that you had made? Yes. That is her answer. It was undisputed that Statesman paid people who stayed. It is undisputed that once they left, their compensation policy was rigid. They followed their contracts. They did not pay any compensation after an employee left employment, whether voluntarily or involuntarily. And that was because they had to have a remaining portion of the standard fee commission to complete the work. Mr. Cardin also misrepresented that it's not true. They did not have a separate person who handled all of the closing transactions, and that's clearly demonstrated in Schedule A that's attached to the employment agreement. It lists about 20 different things that the sales agent is responsible for doing to usher that transaction through the closing process. And Ms. Blackwell also testified that she negotiated with Ms. Mann to receive a portion of those commissions and waive part of her draw that she didn't have to repay it so that she could continue to complete those transactions because she would not have time to just sell things. In addition to that, Ms. Lane, at the beginning of the case, wrote emails, which are part of the court record, saying, look, I wasn't here when these deals were sold, but I'm working to help close them. Do I get a portion of that commission? And Ms. Mann said yes. Because that's how important it is. It is not just enough for them to get a purchase contract, as the court correctly pointed out. They have to usher those people through to closing. Carrying these properties for any length of time, as opposed to what Mr. Cardin wrote in the briefing, is extremely expensive. They have to pay property taxes. They have to pay maintenance costs. They have to pay insurance. They have to pay lawyers. They want to sell properties. They don't want people to pay the first half of the purchase contract and then have to chase them and sue them in order to close a real estate transaction. That's not what they're in their job of, that's not what their profession is. Their profession is a builder developer. They build communities and they sell them. And so what I want to be very clear in my last couple of seconds is Statesman followed the contracts at the time that they were created and all the way through trial. There was no bad faith dispute. They relied upon the contracts as the intent of the parties that they had, to the intent of the parties that had executed them.
Thank you,
Your Honor.
counsel. Thank you for your arguments. We will take this matter under advisement and issue our decision in due course. The court will stand at recess at this point. Thank you.